Hello, everyone, and welcome to Internet Law Review. For today's story, just a couple quick thoughts on the Katy Perry Dark Horse and Flame Joyful Noise lawsuit. So, as we all know, Flame and Joyful Noise recently got a copyright infringement judgment from a jury saying that Katy Perry's Dark Horse copied part of their song. And I'll link below to two things that we should look that I'm going to be referencing. The first is Adam Neely's video on this subject, and the second, of course, is Leonard French's video on this subject, both analyzing this. And they're both good reference materials, and you should probably watch them both to help us understand. But I do have one major point of criticism for Adam Neely's analysis with respect to the expert witness Todd Decker. As he pointed out in his video, Flame got this guy, Todd Decker, who's chair of music, professor of musicology, apparently a well-respected professional in the field of musical theory. And this person, when they were on the stand, essentially testified that they had never heard a progression like that of the song Joyful Noise, and therefore it was something that was unique, and Katy Perry's Dark Horse therefore was a copy of something that was unique. Now, Adam Neely has criticized this on the basis of it's not unique. It's in a whole bunch of other songs. He made a list of other songs that it's similar to, and basically saying that this was potentially a lie or potentially an exaggeration, essentially saying all but he perjured himself in this testimony. The part that I have the most trouble with is Adam Neely doesn't seem to be taking into consideration the fact that there's a cross-examination period. Adam Neely is saying essentially that Flame got this guy on the stand to use a bunch of jargon, confuse and bamboozle the jury, and got them to do something out of confusion rather than out of an enlightened perspective. But if Todd Decker was attempting to confuse, if he was using terms in an attempt to confuse, or even not in an attempt, but just they were confusing, one of the major reasons for trial, one of the major reasons for cross-examination is exactly so. The other side's counsel has the right to question Mr. Decker. So it's not like Flame could put Todd Decker on the stand and he could say all the things that they would wish him to say, and that's all the jury heard. I mean, that's not how this works. Katy Perry's lawyers had the ability to cross-examine him, and they could have cross-examined him about the book that he wrote on the song Old Man River, which, according to Adam Neely, has a similar progression to that of both Katy Perry and Flame's songs. He could have questioned them on the other music that Adam Neely pointed out. They could have questioned him about any sort of buzzwords that they used or any sort of other confusion. And the opportunity to question at trial, cross-examination trial, was almost certainly not the only opportunity they had. They almost certainly did a deposition of this guy before the trial ever took place to ask questions then. They reviewed any reports that he written. It's all part of discovery. Trial by ambush is not really a thing that exists anymore. And Katy Perry's lawyers had the ability to consult their own experts in order to prep, and I'm sure they did. In this kind of trial, with this kind of exposure, this is the things that you would expect an attorney to do. You'd expect them to speak to their own experts to figure out the kinds of questions they should be asking. Attorneys don't always write their questions in a vacuum. They speak to people who are knowledgeable in the field, so they know the right questions to ask. So, Adam Neely is saying, well, this guy was misleading or perjuring himself on the stand, but he doesn't seem to be considering Katy Perry's lawyers had every ability to cross-examine, and almost certainly did cross-examine. I would imagine they asked every question Adam Neely has thought of. They had 3 years to think of it, and I know that Adam Neely has some strong thoughts on it, but these attorneys, and she had plenty of attorneys working for her, would have had every opportunity to think of the same questions. And so that's not being taken into consideration. And the other thing, of course, is that if you really think it's an issue of putting on an expert to bamboozle the jury, well, Katy Perry is the defense. That means that she goes second in order. So she would have the ability to put on her own expert after the other guy to contradict everything the first guy said. And, there's an issue when, that's kind of the last thing you heard because it's the last thing the jury is going to be thinking about. And so you can put on your own expert to say, no, this is completely similar to every other song. Here's a whole bunch of songs. Basically the kind of analysis Adam Neely was doing. You have your opportunity to pull in your own experts and rebut everything this guy is saying. So Adam Neely is criticizing this one expert, but not really seeming to take into consideration the role of cross-examination, not taking into consideration the fact that that they had the right to put on their own experts to contradict what this expert is saying. And I would imagine that that's exactly what happened. The jury had that and other evidence. It's not like they just heard from this one guy. So that's something that Adam isn't really taking into consideration here. So, from a legal standpoint, I take some minor exception to Adam Neely and other people who don't seem to be factoring in the role of either cross-examination to challenge the expert or the ability to put on an expert of their own. And the fact that these lawyers working for Katy Perry almost certainly, if they didn't even put on an expert, which I'm sure they did, had an opportunity to gain expertise from experts to know what kind of questions to ask. So it's a little strange to me that you're not taking that into consideration. So that was the legal point. And then I want to discuss a bit of a philosophical point on the issue of substantial similarity. There's been a lot of criticism of that issue too because of the standard. And the essential problem that we're trying to solve here is that if you have a work, it can't be like you just change one thing that's no longer a copy. That would be absurd. It's not like if you take Harry Potter and the Sorcerer's Stone and change one word in it, it's no longer the same book. That would be absurd. Of course, if you change every word, it's definitely not the same book. And so this is kind of the ship of Theseus problem. It's like, how many things do you have to change until it's no longer the same work? And while the ship of Theseus doesn't have an answer to its problem, in copyright law, we solve this problem by saying the answer is substantial similarity. It's not an absolute copy. It's not striking similarity. It's not minimal similarity. It's substantial similarity is the way we solve the problem. And that ultimately is a question of fact for a jury because it's an issue of, do you find these works to be substantially similar or not, given all the evidence that we've presented. So, I don't have an obvious problem with the jury verdict right now. I'm assuming that they heard every bit of evidence that Adam Neely has tried to brought to their attention, and they looked at this and they said, yeah, this bit of this song is the same as this other bit. It's not an unprotectable element. It's not just the notes, it's the way they're presented, it's the overall tone, it's all the factors that Todd Decker's talking about. It's not just one factor, it's multiple factors topped onto each other. It's this, and that combines the unique sound, and it's the same over here, and therefore it's the same. So, it's not just an issue of the tone, it's not just an issue of the notes, it's not just an issue of, it's everything taken together, and whether or not substantially similar or not. So I don't have an obvious problem with the jury verdict. I don't know that it changes the law very much. And if there's an issue with the elements being unprotectable, then maybe it's a legal question that will be decided by a court of appeals. But at least on my opinion, and I'm not a copyright lawyer by practice, I'm a patent lawyer, so I'm not as educated as Leonard on this. But, because it's intellectual property, I have a fair knowledge of copyright law. It's something I have, pretty heavy education on. But given what I know, I don't have an obvious problem with the jury verdict because I'm assuming that they heard every bit of evidence that Adam Neely had wished they'd heard, and they debated and they deliberated and they came to the decision they did. It doesn't seem obviously wrong on its face to me. And it's an issue of, did they take enough of the ship of Theseus to say that it's improper infringement? And the jury said, yeah, it's not just one plank out of 100, it's some substantial number, whatever that is, it's enough. And so those are just 2 points of supplemental critique I want to add to this equation because I feel like those elements have not been discussed. But that's all I have for tonight. I hope you're well. Until later, cheers and goodbye.